What is e-discovery? What are the laws that govern e-discovery? And what can I do to prepare?
Greetings. My name is Bill Dean. I'm the Director of Computer Forensics and Electronic Discovery for Sword & Shield Enterprise Security. The following short video will provide you with the basic information needed to successfully navigate today's e-discovery challenges. Let me begin by conveying that 98% of all information today is created electronically. This means that the majority, if not all, business records and communications are created and stored digitally. Where the source of information needed in litigation used to be here and here, it is now located here and here. Now that the information sought after in litigation is in the hands of technology departments, e-discovery is becoming an additional responsibility for today's organizations. Because of this shift in litigation strategy from paper information to technology, the rules governing litigation have also and are continuing to change. On December 1st, 2006, the updated rules of civil procedure went into effect. These rules place electronic information on the same level of importance as paper information in litigation. The federal laws, as they relate to electronic information, had not been updated since 1970. When we look back as to how rapidly technology evolved through those 36 years, the need to update these rules were well overdue. The rules provided standard terminology for all digitally stored information. Digital information of any sort is now referred to as ESI, or electronically stored information. 10 of the federal rules were updated. We will cover 4 of these laws today, as I feel these 4 have specific technical implications for today's organizations. With the federal laws in place, state courts are quickly following suit. As of this recording, 38 states have also enacted e-discovery rules. Let's briefly cover the technical implications of 4 specific federal rules. The courts recognize that data for litigation purposes generally falls into 2 distinct categories: data that is reasonably accessible and data that is not reasonably accessible. The courts realize that some data is easy to retrieve and some data is very hard, expensive, or impossible to retrieve. This is referred to as two-tiered discovery. The primary differences between the two are the cost and complexity of retrieving the information sought. Simple examples of data reasonably accessible would be undeleted emails or files available on a file server. The courts refer to data not reasonably accessible as undue burden or cost. Typical examples of data not reasonably accessible would be deleted emails from years ago or data on backup tapes that are years old. However, to consider data not to be accessible due to undue burden or cost, that claim will have to be justified using some method. Rule 26F is known as the meet and confer. Although there is not a technical translation for Rule 26, there are important technical implications. This is the meeting in which counsel representing both parties determine the rules for engagement. Topics involve specifics such as adequate preservation steps, the ESI agreed to be discoverable, and the form or forms that the data will be produced. The importance of this meeting is to prepare your legal team by explaining your technical environment so they have an adequate understanding of what is and is not feasible. If possible, a technical resource with an overall understanding of your environment would be a great asset for your legal team to have available for this meeting. These steps will help ensure that processes discussed and agreed upon are feasible and to ensure that the agreed upon preservation steps have a balance between preservation and the need to continue the routine operations of your organization. When the federal rules were proposed and scheduled to take effect in December of 2006, many companies felt as though the sky was falling. We thought we were going to have to keep all data perpetually in the anticipation of litigation, and many product vendors were reinforcing this misconception. Rule 37E, previously Rule 37F, is better known as the Safe Harbor Rule. This rule is what saved us from this burden. The rule states that absent exceptional circumstances, a court may not impose sanctions on a party for failing to provide ESI loss as a result of a routine, good faith operation of an electronic information system. This recognizes that some computer systems routinely alter and delete information without specific direction from an operator. A simpler way to describe this would be data retention policies. As an example, a company that has a 365-day email retention policy may not be responsible for emails past 365 days. However, there are some stipulations to this rule that must be observed. First, the company must have the approved policy and automated retention schedule in place leading up to litigation. A new retention cannot be implemented when a company is under a litigation hold as part of a litigation strategy. A litigation hold is when a party is under a duty to preserve information because of pending or reasonably anticipated litigation. Second, a party cannot exploit the routine operation of an information system to thwart discovery by allowing a system to continue to destroy information that it is required to preserve. This is considered spoliation and can carry financial sanctions or devastating legal consequences. To further our example, a company with a 365-day email retention policy must cease the automated routine for the identified ESI to prevent the inadvertent destruction of this information. For specific details of how the Safe Harbor Rule would be applicable to your situation, be certain to obtain the needed information from your representative counsel. Rule 45 is the subpoena rule. I wanted to bring this to your attention that you may not even be a party in litigation and may be asked to produce ESI. Now let's move on to the overall goal of the e-discovery process, to start with the raw data set and to reduce it to the point of what could potentially be related to the matter in which you are involved. As e-discovery experts, we begin with the world of potential information, the source data set, and perform various culling operations to reduce the data set. The initial step in culling the electronic information is to start with the defensible identification and collection of potentially responsive data sources, such as custodians, file types, subjects, dates, and recipients. The next step would be known as the technical process as denisting, which removes known files for the operating systems and applications. We then remove pictures and multimedia files if they are not of interest, and remove exact duplicates based on file hash values. We then apply the parameters agreed upon, such as timeframe filters, custodian details, and the agreed upon keywords. At that point, we provide the remaining information to your legal teams for the critical review step. The importance of the review process is for legal teams to identify privileged and potentially confidential information, then to perform the needed redaction of the specified documents. Once the review process is complete, the designated information is produced to the opposing side in the formal forms in which it has been requested. The EDRM lifecycle is the methodology typically used in e-discovery matters. The first phase, information management, is the proactive manner in which companies maintain their information. The identification phase is the step of determining the key players in the litigation matter and where their ESI is potentially located. Is the information sought on laptops or company servers, home computers, smartphones, or maybe it's in the cloud? Collection is the phase in which this ESI information is gathered. Once the information has been identified and collected, the party must take the appropriate preservation steps to avoid the inadvertent destruction of the information sought. Now that we've identified, collected, and preserved the ESI, it is time to cull down the information in the processing phase using the methods we previously discussed. Once the culling process is complete, the information is provided to the legal teams for detailed review and analysis. Finally, the appropriate information is provided to the opposing legal teams in the production phase, and then presented to the courts as needed. With the federal rules in place since 2006 and states quickly adopted rules to address ESI, one of the best steps a company can currently take is to proactively prepare. We conduct e-discovery seminars along judges and attorneys for various bar associations. One thing has become vividly clear from the court's perspective. There is an expectation for companies to consistently and rapidly produce electronically stored information while in litigation. The best way to meet this expectation is to prepare now by developing an e-discovery readiness plan. To be successful, you must first identify the locations of your electronically stored information. As simple as this may sound, this can oftentimes be very challenging. Once you have located all of your ESI, it would behoove you to classify the information as either reasonably accessible or not reasonably accessible in preparation for Rule 26b-2, the two-tier discovery rule. The next logical step is to identify ESI that will be deleted and the method of deletion. Combining this with reviewing and potentially updating various document retention and information management policies will prepare you for the aspects of Rule 37E, the Safe Harbor Rule that we previously discussed. Another crucial step is to prepare detailed litigation hold procedures. In many instances in which companies have been given monetary sanctions, it has been due to lack of proper preservation. Detailed litigation hold procedures will help ensure a routine process for proper preservation. The technical processes of e-discovery often require unique tools and software to be successful. During your preparation, determine the tools and resources that will be needed and proactively make these investments. If you prefer to use a third-party vendor to handle your e-discovery matters, engage them now. Allow them to assist in the creation of your e-discovery readiness plan. The more knowledgeable your e-discovery consultant is of your technical environment, the smoother the e-discovery process will be overall. A final step that we will discuss today is the creation of a data map. Your data map is a graphical representation of your information technology landscape that describes the data flow, storage, and the locations of your ESI. This data map provides value to your legal team and to the courts when explaining your environment in phases such as the meet and confer that we described in Rule 26F. The complexities of e-discovery can quickly become evident when companies are involved in litigation. A very common challenge in e-discovery is proper communications between technical and legal teams. Although these fields are beginning to work more closely, there are still drastic differences in these professions in both terminology and levels of understanding of each other. An example is when your legal team communicates that you are under a preservation hold and that no information should be deleted. Information technology professionals often take this at face value, so they don't delete any information. However, what the legal team was conveying was not to allow any information to be destroyed. This may involve backup tapes, automated data purging routines, and data that's even hosted offsite. Many times, the breakdown in e-discovery can be traced back to either a misunderstanding of the technical environment or a breakdown in communications due to incorrect translations from legal terminology to technical terminology. As with other compliance issues, such as SOX, PCI, or HIPAA, e-discovery challenges cannot be solved with a black box. As we previously discussed in the EDRM model, it is a process of people, planning, and technology that enables successful e-discovery responses. One of the largest issues facing organizations involved in e-discovery is the potential of unpredictable costs. Much of the e-discovery pricing structures revolve around the volume of information. Unfortunately, with this model, a company may be well into the processing phase of e-discovery before accurate cost estimates can be provided. To provide predictable costs of e-discovery engagements to our clients, Sword & Shield now offers a standard pricing model that spans the technical portions of the EDRM model. The final e-discovery challenge that I will discuss today is determining what tools, training, and resources will be needed. Some companies may choose to handle aspects of e-discovery internally for various reasons. For those of you considering this route, begin determining what tools and training you will need now. Go ahead and purchase these tools and invest in the appropriate training. Some e-discovery solutions are actually available on a software-as-a-service model, allowing you to only pay for usage rather than making the capital investments to bring the e-discovery solutions in-house. The technologies used for e-discovery are different from what most companies have in-house, and some can be very complex to use properly. To ensure the process goes smoothly and to keep your legal teams from unneeded concern, you should train and become proficient with the usage of the e-discovery software before litigation begins. If you choose to outsource e-discovery, begin developing these consulting relationships now. A great step in this relationship would be to leverage their expertise to assist you in the development of your e-discovery plans and data maps. This will properly prepare you and allow your e-discovery experts to become knowledgeable of your environment to assist when the e-discovery request does arrive. In summary, the litigation landscape is now focusing on technology for information. 98% of all information today is created digitally, and legal teams realize that computers now house the information they are looking for. The updated Federal Rules of Civil Procedure that took effect on December of 2006 and the 38 states that have updated their rules to address ESI place electronic information on the same level of importance as paper in litigation. I read case law monthly where companies are given monetary sanctions for not properly complying with e-discovery requests. In many of these cases, the failure stems from either a failure to properly identify and preserve ESI or a communications error somewhere along the line. E-discovery processes are unique from a technical and resources perspective. This uniqueness will vary from company to company. There is no black box that will solve your e-discovery issues. The best advice available for companies is to begin preparing for e-discovery now, before you are involved in litigation. This small investment will pay dividends when litigation requests do occur.